We'll let you know at the end of 5 minutes, and then we'll hear from the appellate.
Okay. May it please the Court, my name is Martin Sherman. I am appealing the granting of equitable subrogation to Deutsche Bank. This case is controlled by this Court's Velasquez decision.
Which you didn't cite, right?
Which I did cite in my reply.
Okay, yes. Not in the appellate.
I wasn't aware of it prior to...
We're fully aware of the case.
Okay. All the material facts are the same, and the reasoning of Velasquez...
And Deutsche Bank says the case is different because that case involved a sale, and this case doesn't involve a sale. That's their position.
That's what they say. And I probably argue with the Velasquez sale. However, equitable subrogation is not limited to sale situations. The exception only applies if there is no injury to other mortgagees, and injury can flow from...
How were you injured? You and your wife as second mortgagees, how were you injured?
Well, when the Washington Mutual failure to note and pay off our properly recorded mortgage resulted in harm to us.
And how did that happen? It's not entirely clear from the record because there's some payoff letters there.
There are payoff letters.
How was it that mortgage didn't pay off?
We'd like to know. We still don't know this. In the initial complaint, they stated that we were paid off.
It seemed that you were represented by an attorney.
We were represented.
Wasn't it that attorney's responsibility to be sure that your mortgage was paid off?
Our attorney sent the payoff letters, and we assumed at that time, both the attorney and myself, that she didn't qualify.
And instead, what happened was the refinancing bank, the predecessor to Deutsche Bank, paid the borrowers, the owners of the home.
That's correct.
And that took all the equity out of it.
That's correct. They paid more than was sufficient to pay off our mortgage.
Also, the monthly payment of the mortgagor on the refinanced debt increased by about a third.
That's correct, and which made us immediately put us in a worse position than we would have been. We would not have placed the mortgage in second position to the $900,000 mortgage. At the time, the $688,000 was behind. I actually had the ability and access to pay that off had there been a problem. Plus, it's not stated, but I'm a real estate broker for 29 years, and I originally sold them the house in 1989. And we had agreed, Madigan and I had agreed that had she not had the ability to pay at the end of the balloon, and we timed the balloon because I had two kids in college at the same time, a senior and a freshman, and I knew I needed the money at that time. But I did have access to credit lines that were in excess to be able to pay off that $688 3-month loan. I do not have the access now to pay off the $1,188,000 that the judgment was for.
So what would be your remedy then, Mr. Sherman?
Remedy would be to reverse the equitable subrogation, which was based on page 22 of the trial transcript, which was 23 pages, a matter of minutes. The court stated that we had a second mortgage, and that said second mortgage, and therefore it's a second mortgage. And the statutes, recording statutes, state that we were recorded first, and
your point is you'll be recorded first, and when something gets paid off, you will be first to collect.
That's correct.
Okay, you've used up your 5 minutes. Why don't we hear from the referee, and then we'll hear from you.
Hey, please, the court. My name is Jack Bell. I represent the appellate Deutsche Bank. Just to address a couple things, there were no payoff letters from either the closer or the predecessor in interest on the subject mortgage.
How did that happen?
They never received a payoff letter from his attorney.
Let's put ourselves in the position of Washington Mutual, the predecessor to Deutsche Bank, before this new mortgage got packaged up and sold to the public. But let's put ourselves in the position of Washington Mutual. Their mortgage is of record.
Yes, it is, Your Honor. And that's
normally it would be identified and paid off, isn't it?
Typically it would be, but as we see in these equitable subrogation claims, what happens typically is they get a title commitment, and it's not on the title commitment. That's what the bank relies on.
So we have an exception for equitable subrogation when that sort of negligence occurs, but it only occurs if the existing mortgagee is not injured.
Right, and under this situation, the existing mortgagee is not injured because it is still in second position.
He's in second position to $900,000 instead of $600,000, isn't it?
And he only became in second position because the amount of the loan was increased, thereby causing the default.
Okay, if I can address both. Judge Schwartz, it's not a $900,000, if I may correct the court, due to the theory of equitable subrogation, that $900,000 mortgage does not exist. This legal doctrine provides that the subject mortgage sits in the shoes of the predecessor, and that's really the issue of
$600,000 plus only attorney's fees plus everything else.
As if the first mortgage,
default interest and so forth.
Correct. As if the first mortgage went in default,
yes,
which it would have done, and that's what the court has done. And the Florida courts, including Altamirano, which I believe you were involved with, have specifically addressed the prejudice and the fact that there be unjust enrichment in a second mortgage situation if they're able to take all that money, not be accountable for all that money that is used to pay taxes, to pay insurance premiums, and so forth and so on. Now, in regards to your question, Judge Cortinas, I believe you asked in regards to the increased monthly payments.
But how are they not prejudiced when they had a $100,000 second mortgage, and now you've increased the amount of the first mortgage and caused the mortgagee to have to pay almost an extra $2,000 a month?
Okay, well, I beg to differ in terms of increasing the amount because we're in a equitable subrogation situation where the only thing that they have...
So there's no increase in the amount because the mortgage is not only the principal amount, it's all the other costs that go through which were not paid by the mortgage or...
Right, and it's as if we're the original mortgage and it went into default.
No, you're fast forwarding here. There was an original mortgage.
Right.
Then your mortgage paid off the original mortgage and had an increase of $100,000 plus that was given to the borrower.
Yes.
Right?
Right.
So an extra $100,000 was now placed in front of the Sherman second mortgage. Right?
Yes, until the equitable subrogation takes place, and we lose that money.
Maybe we can address risk, which I think is what Judge Cortinas is driving at. If we take the moment that the refinancing has occurred, and we look at credit risk, two things have happened. Number one, the home is more highly leveraged, right? It has $900,000 plus $200,000 instead of about $700,000 and $200,000, correct?
Right.
And second, the monthly payment by the owner over the next year until default occurs is 30% or so higher, isn't it?
It is until the doctrine applies. And what happens in this case is that we go back to...
Well, you want to put the doctrine before the reality of prejudice. Have they not been prejudiced by your increase in the amount of the mortgage?
No, they have not.
The principal amount of the mortgage.
No.
There was an increase of $100,000 in the principal amount. You didn't have to pay that in order to retire what everyone seems to agree is the first mortgage. You didn't have to pay the $100,000. That $100,000 went to and has to be repaid by the mortgagor. And it's the first lien, according to your theory, on the property. I know it's more than $700,000, but it's $100,000 more than even with the $700,000 plus all the other obligations of the mortgage, isn't it?
It may take me a little bit to explain this, but this is the way I understand it. At that moment in time, until there's an equitable subrogation, yes, the mortgage was higher, absolutely. What's happened, though, is that we have set in the shoes of the first mortgagee, and the monies that were paid as to that earlier existing mortgage have been credited against the new equitable lien, which would have been stepping in the shoes of the first mortgage.
I don't,
In terms of foreclosure.
I do not understand that.
Okay.
I absolutely don't
Sure.
understand that.
The-
You, under this under this judgment, you have what amounts to a first mortgage for $100,000 in principal more than the mortgage that you have retired. Isn't that correct?
That's not correct, Your Honor. All due respect.
Tell me why.
Sure. The equitable subrogation lien is the amount of the payoff of the first mortgage.
It's not the, well, where is the additional 100,000?
It's gone. The bank lost the difference. Absolutely.
But the amount that was credited was $726,940 in the final judgment.
That's correct, Your Honor.
The payoff of principal at the time the refinancing took place was much less than that. It was 600 and some, wasn't it?
Plus, there was interest due through that time. There was also a
Prepayment penalty of
Yes, and there's no case
$24,000.
law on that. If the court needs to remand we'd say, okay, remand us to that specific item. There is no case law on that. And the court was in equity, and the court decided to include it, but that's something that is not addressed by any court.
Let's address something else.
Yes,
What
sir.
about your adequate remedies at law? You had your client's predecessor in interest had professionals as well, correct? A closing agent, title insurance,
That's correct, Your Honor.
lawyers. Why don't you have adequate remedies against each of those professionals who allowed this to occur?
I think we do have an adequate remedy, but it has to do with title insurance, which title insurance allows the title insurer to step in the shoes and proceed with subrogation rights. And that's what's happening, quite frankly, in this case. And to protect the collateral and to get the collateral for the bank. The prejudice comes into play. The Senate Court dealt with this very situation, the first DCA case, situation where the refinancing lender refinanced the first over a second, and in refinancing, there was adequate monies to pay off that second mortgage. And the Senate Court did not state that prevented equitable subrogation to take place. The Senate Court noted that a second holder at the point of negotiating a second mortgage takes a risk and accepts its position in the event of a foreclosure with respect to the amount lent on the first mortgage. And in that case, the court allowed equitable subrogation.
Anything else, the additional $100,000 in principal was lost.
But we lost
Because you don't have an equitable lien on that amount. Is that correct?
Absolutely. We
You
lost,
just succeed to the first mortgage.
We lost $160,000 right out of the box run. That's correct. And the Senate Court looks at what happens when a foreclosure takes place. And second mortgage is subject to the risk of being foreclosed out by the first mortgage.
That's right, but this is a different case when you've increased the amount of the first mortgage, thereby increasing the potential harm to the second mortgage. I mean, my question remains, how do you distinguish the last case that talks about harm? And here, if we believe harm was done to the second mortgager,
Yes, sir.
how are you entitled to equitable subrogation?
Velasquez, we would distinguish it as a sale of property case. The other big consideration by the third DCA was the expectation of the third mortgagee, which was Mrs. Velasquez, in that the mortgage specifically had a due on sale clause. In this case, there is no due on refinancing clause. In fact,
I understand that there's no due on refinancing clause. However, Velasquez talked about harm, and they talked about situations that you apply the doctrine of equitable subrogation, and I wonder whether it applies here. How can you not say that the second mortgagor was not harmed by an increase in the first mortgage?
first, I disagree regarding an increase in the first mortgage. That first mortgage
would have been in the same amount that the court entered judgment in.
I understand because you want to carve out the 100,000 and leave it out there in cyberspace. I'm going to put the 100,000 in because that was part of the refinancing, right?
Correct, Your Honor. It was
That's not in
$900,000.
cyberspace. It's a real debt now owed by the borrower.
But isn't that at best a third mortgage? The $100-some thousand is really a third, because you can't for the exact reasons that Judge Cortinas is saying, you can't harm the second mortgagee by putting that additional amount ahead of him. So you've got the $160,000 plus everything else is really in third position, isn't it?
Technically, you may be right, Your Honor. We never got to that step. But in terms of prejudice, the courts dealt with the refinancing, same situations, and the prejudice occurs if that additional $160,000 that we lost is actually put into the judgment. But that's not the case here.
Well,
We'd ask that you affirm.
Thank you.
Thank you.
Mr. Sherman, you have 5 minutes.
I'd like to point out a few other facts in the case. Washington Mutual was a voluntary lender who gave $900,000 adjustable rate mortgage with a starting interest rate of 9.2% with a cap of 15.2% to a widow with no income verification who was already delinquent on her first mortgage at the time. And this is in the appellee's answer brief. If that's not a case of predatory lending, I don't know what is.
but it probably was creditor lending, but the mortgagor has a complaint about it because they don't have a lien, and their equitable lien, which is on appeal, is not for anything more than the first mortgage. Isn't that correct?
That's somewhat correct. But they
which somewhat?
Well, your point would be that at that point that they were behind in their mortgage, if it had been foreclosed on, you might have gotten back proceeds to pay off the second mortgage.
That's correct.
The fact of the matter is what happened was instead of foreclosing, they actually increased the loan amount, thereby prejudicing your second mortgage.
And keeping us in court for 4.5 years while the properties were declining. The attorney made sure that also.
That's why you should have been in the legal business instead of the real estate business.
Well, I've been enough close that. I'm glad that Mr. Bello has brought this up. Mr. Bello represents the title company, not the.
There's nothing evil about that.
Nothing evil about that. But some years ago, I purchased the property, and some months later, a title problem came up. My attorney called the title company. The title company wrote a check, paid off the lien, and that was the end of it. Until from 1977 to 2008, I thought that that's what title insurance was for, to satisfy liens that they did not find out. They collected $4,575 in title insurance fee.
The title commitment that is in the record looks like it missed your mortgage.
It missed my mortgage. It stated that the first mortgage was not $688,000. It stated the first mortgage was $888,000. It stated that Mrs. Manigan was a widower. This was just total incompetence on the part of these closing agents. I've seen closings not close for less mistakes than these. There should have been a double title search done if there was mistakes made. Apparently, they claim that the payoff letters that my attorney sent out, they didn't receive. However, if let's just say for argument's sake that she applied to 3 different mortgage.
But it was your mortgage was a record. So
A record.
It didn't matter whether it was a letter or not. The letter was meaningless.
Right. 2 other lenders found it without no problem. And in their initial complaint, they stated that we were paid off.
And then they amended when they found you weren't paid off.
But what made them think that we were paid off? Unless
Because they gave $100,000 more than they had to.
I thought that there was possibly a forged document stating that we were paid off. Mrs. Manigan said at the closing, in her deposition, which I had no privy to, we had requested it, It wasn't given to us after the deposition, it wasn't given to us at the trial, when it was entered in evidence. It wasn't given to us when we called Mr. Anderson and requested it. We even requested, tell us who the name of the court reporter is, so we can get a copy of it. We didn't see it until we got their answer brief. Mrs. Madigan said, in no uncertain terms, that we had an agreement that she would pay off. She said she wouldn't take a loan unless we were paid off, that we had an agreement to be paid
So
off.
she agreed to, in essence, to pay the $150,000 of it plus whatever to you.
Right, $100,000. And also, she also said in deposition that the mortgage broker stated that we signed, my wife and I signed, a subordination agreement. We didn't sign a subordination agreement.
You've used up the remainder of your time, and you'd like us to reverse.
I would like you to reverse. Thank you.
Thank you.
The next case is, Crow